Hello, I'm Ken Trapetta with NAR's Government Affairs Division, and I'm here to tell you about some big changes that will be coming in August, both to the settlement forms and the loan disclosures and the settlement process in general. As many of you might know, August 1st we'll be seeing changes to the good faith estimate and the HUD-1. Both will be going away, and we'll be implementing a new loan estimate and a new closing disclosure in their place. This is being done under the Dodd-Frank Wall Street Reform Act, and the idea is to improve the settlement process for consumers. So let me talk a little bit about the rule itself. As I said, we're changing the forms. Goodbye to the good faith estimate, goodbye to the HUD-1, goodbye to the truth in lending disclosure. The changes to the closing process are the thing that is going to be of most concern, I think, to NAR's members. And that's because the closing disclosure has to be given to the consumer 3 days before closing. And while things on that disclosure can change, as we've learned through the implementation, fewer of these changes are going to be as easy as we thought. So major changes to the disclosure, such as changes to the interest rate or the loan product, would require another 3-day disclosure period. But other changes to the disclosure may require approval from a lender who may not be at that closing table. So NAR is offering our members this advice, and that is, if you plan to close a transaction on, say, the 30th of September, make sure your clients have all their ducks in a row by the 23rd of September. This way, there won't be any last-minute changes at closing. Because while, as I said, you can make changes at closing, it may be more difficult than it is today. And so you should try to avoid last-minute changes. And to sellers, make sure your sellers abide by their agreements. Make sure they don't make changes or take things out of their home that they said they were going to include in the home, because these types of things could lead to changes in the settlement statement, which would require going back to the lender and getting an approval. Another bit of advice we're giving is keep your communications tight between you, your clients, the other realtors, the loan officers, the processors, and the settlement agents, so that you're all on the same page, so that you're all making sure that you're really ready for that closing, in order to make the closing smooth and a good transaction for your clients and customers. One more thing I've been telling folks is add 15 days to the closing time on the transaction. If you're in a state where you close deals normally in 30 days, anticipate taking perhaps 45 days. If it's 60 days, maybe plan on it being 75 days, just to give that extra leeway. This rule has a lot of, in addition to the 3-day waiting period, certain disclosures have to be given in a certain amount of time. There has to be a certain amount of time for the consumer to think about what they've got on that disclosure. And so all these things are going to potentially add time to the transaction. Now, will it be 15 days? Maybe it won't. Maybe it'll be only 4 or 5 days. Maybe it'll be no time at all once we really get settled with this process. But the safe bet is to do 15 days. And as I noted earlier about changes, say, to the walkthrough process, that's another area where you do the walkthrough early enough so that if there is a change, it can be addressed without having to go to the lender or to redisclose the closing documents. Basically, the idea here is to avoid a problem at closing. Now, after 6 or 7 months, I think maybe we'll find that we'll have a list of things that can change at closing. Something will happen 10 or 12 or 13 times, and that won't have to be approved by some lender in Nebraska or some office in Florida when you're closing a deal in California, some lender office in Florida. But in the meantime, we expect that those changes are going to be required to be approved, and so you should try to avoid making changes at the closing table if you can. NAR plans to do a lot more education on this in the 6 months, 5 or 6 months coming up. We will be doing more webinars, and so stay tuned for that. And of course, keep visiting our webpage, realtor.org/RESPA, for more information on these changes and other things going on with the Real Estate Settlement Procedures Act and the Truth in Lending Act.